Vice Chair Mark?
Great, thank you. I think it's the speaker placement. So we skipped one item in our agenda. It should have been under legislation, review and discussion of possible legislative concepts, item G2, and then G2A. Okay, we're all square. So, agenda item G2A, legislation, review and discussion of possible legislative concepts. The first one, legislative concepts regarding business and profession code 7124.6, including the disclosure of an accusation to revoke a contractor's license on the license of personal record, and the number of years of disclosure of a citation, public reapproval, and criminal conviction. This agenda item is here because there was a legislative concept staff meeting, and then there was attended to present at the legislative committee on March 21st, 2024. We actually did not have insufficient time because we lacked quorum. I'll ask David Folk to introduce the first concept, and Deputy Registrar Jaminski will introduce the second concept. We'll ask for board comment after introducing each item, but this will not be a voting item, so there's no staff recommendation. We are on pages 229 and 230 of the first concept relates to public disclosure on a contractor's license. Turn it over to Register Folk.
Thank you, Legislative Chair Mark. Just some background. We're very fortunate at the Contractors Board to have what I look at as an enhanced disclosure policy. And this came about because of construction industry support, where they wanted consumers protected against contractors that had engaged in acts that either had resulted in a disciplinary action or were likely to result in a disciplinary action. So the first one is open investigations. If we receive complaints or one complaint against a contractor and we believe that it will result in either a referral for a potential criminal filing or for an accusation to suspend or revoke, once we meet that threshold, we can disclose that complaint and other similar complaints on the license record. This requires a supervisor approval. Letters of admonishment, something relatively new. We have public disclosure for 1 or 2 years. Citations, 5 years from issuance. And what's important about this one is it was a few years ago that the board sponsored legislation to ensure that citations were disclosed on any other license the qualifier may appear. At that time, we were including on the caption of our accusations related entities. And because we were able to do that, and the Attorney General's office drafts our accusations, we didn't believe we needed to add that same language to this section of laws to relate that would relate to accusations as it does citations, to provide the disclosure on the related licenses. And then you'll see accusations. If it's a settled accusation where the contractor is put on probation, it's disclosed for a period of 7 years. If the contractor is revoked, then it's disclosed indefinitely. Now, why we flag this for you today is because we do believe we need a ledge proposal in the future, and that's what was going to be addressed on March 21st. We did run out of time, but we hope to bring this back to either the ledge committee or to the full board with a ledge proposal that will do the following. We want to make sure that accusations, when they're in the process of being drafted, appear on the related entities. As it is today, the accusation only appears on the respondent entity and any sole owner licenses the qualifier may have. And that poses a consumer protection vulnerability if that qualifier is to obtain another license before the accusation process is completed. There would be no disclosure on that other entity or any other entities that qualifier may currently appear on. So, we want to fix that. Public approvals. We never ask for a public approval. When we take a legal action, it's one of those that I previously mentioned. It could be a citation, a letter of admonishment, or an accusation. We don't ask an administrative law judge to have a finding for a public approval. Just for some quick background, if we take an administrative action, the respondent, whether they're licensed or unlicensed, they have the right to have a hearing in front of an administrative law judge. The exception would be the letters of admonishment. We can hear those internally. But what we find is that other DCA boards and bureaus, it's common for having a public approval. That's like something in the medical industry. Perhaps there needs to be something on a doctor's record that would be a public approval. We don't generally have those here because we're looking at restitution, putting somebody on probation, getting a disciplinary bond, maybe having them take some courses. But nevertheless, if we get a public approval, how long do we disclose it? So we don't have anything in the statute that says how long it's disclosed. Generally, we're looking at, I think, 5 years for a public approval, but that's being questioned. You know, what should it be? We're going to need the board to weigh in on that and to establish a time frame to publicly disclose a public approval. The next one is criminal convictions. We generally have a companion administrative action, but not always. How long should a criminal conviction be disclosed if we didn't take an action? Just, you know, I don't think I'll throw out in public here the time frame for that, but I think what we should do is come up with something in the statute that says how long a criminal conviction will be disclosed on a licensee's record. And the other one is the unfair business practice. You know, what we're having to do on those is we generally do a companion complaint, but the reality is the DAs are generally the ones, district attorneys are generally the ones that are filing these 17-200 unfair business practices. And they don't, is a rule, they don't appreciate an administrative action supplementing their unfair business practice because they don't need it. You know, they might be looking at our violations that were violated. It makes it a little bit more complex. We don't need to do that. We need to be able to disclose an unfair business practice. This is important to consumers who are being taken advantage of by contractors that are being financially enriched by this. We have a very good case right now with the carpenters that got the Attorney General to file. It's an unfair business practice where we really have widespread wage theft where contractors engaged in drywall installation were being paid less than minimum wage. We should be able to disclose that. We should have early disclosure without having to to identify a way to have some type of an administrative case. And what we find ourselves is trying to ask to be added to the caption of the 17-200, which doesn't meet with always with a favorable response. So we want to add that to our statute too. It's an unfair business practice that's been filed. Hey, let's disclose it and let's be able to publicly state for how long. So just flagging that for you today. And we look forward to coming back with the well-vetted ledge proposal for your consideration.
Thank you for that. Is there any specific board comment on this? I'll say a couple words. At the legislative committee meeting that was last held, a consumer from the public actually did comment something similar to this, if my ledge committee members remember, about looking up online. The individual did not have previous issues that were part of this license, and so they could not identify. So what David Folk is actually proposing is, this is what I'm hearing, is trying to help clean up our online public disclosures and actually make that a CSLB bill in the future. Is this something in the past, there's always been kind of like a committee set up to kind of hash it out? Is that what you're looking for? Even though we're not taking action, but, board chair Love could in the future appoint some sort of committee to work this out.
Yeah, I guess that would be up to the chair. If you'd like to consider appointing a two-person advisory committee to work with us on that, that would be fantastic.
We will discuss that. Yes.
Yeah, probably at a future time. As current ledge chair, I would like to be on that committee, but then I would assume someone else from the ledge committee would like to be on that committee as well. So maybe if you have interest, please contact Chair Love. All right, anything else on this one, Dave?
No, that's it. Just, I guess the second one, Mike Jaminsky was going to cover.
Yeah,
Oh, there's a question. Apologize.
No question, but Mr. Chairman, I would volunteer to be on that committee too. You're the chair.
Okay, we got. All right, thank you. So obviously, Chair Love appoints all committee members, so thanks for the consideration. If there's anyone else that would like to put their name in the hat, please let Chair Love know. Back to you, Mike.
Yes, just real quickly, not much to add here other than what's in the packet. We just went through our sunset review process, and as part of that process, the legislature asked us a lot of questions for us to answer about specific issues, and we're pretty good at doing that. This one was unique, and we just thought we'd ask the board to provide any thoughts if they have any at all. So right now, the state law provides that the CSLB board include, as far as contractors go, right? As far as contractors go, 1 general engineering contractor, 2 general building contractors, and 2 specialty contractors. The legislature has asked the board if the board member composition should include a B2 contractor license on the board, given that there's now a new B2, right? We're not in the specialty contractor realm. We're now in the general contractor. We have the A and the B. Now we have a B2. So the legislature is asking, what do you think about having a B2 on the board? Informationally, for everyone, there are currently 721 B2 contractors. The license classification took effect in August 2021. So that is the idea. It's not that I'm aware of included in a sunset bill currently, but it's been asked, so we thought we'd try to provide a response. So I'll leave it at that. Anybody have any thoughts?
I'll comment. I'm a B license. I hold a B license seat. B licenses make up 103,000. The CSLB contractor's license, I think there's about 300,000, so it's a little less than a third. So I think moving a seat to someone that's one of the smallest subsets on there doesn't make any sense. Yeah, I think I see the B2 as a subset of the B, so I think it should be currently held by 2 Bs.
Yeah, I think partly what Mike was saying is B2 does not allow any, to your point, B2 does not have allowable any seat on this board. So to your point, having 2 B licenses currently and the ability for a B2 to be one of those Bs. Is that what I was hearing from you, Alan?
Yeah, I think the B2 is a subset of the B, right? It's the same as a B, but without framing. Is that correct, right, Dave?
Yeah, without framing, it also precludes behind-the-wall electrical and plumbing and something like that type of work. As
So
far
I
as-
think it's too small of a subclassification to assign its own seat to.
Yeah, and increasing our board, but I think just what Sunset was saying was they just don't have an opportunity to sit at all. But I agree with you, it's not really fair to the 100,000 B contractors. But I think maybe, and maybe I don't know this, Mike, you might correct me, is somehow the ability for a B2 contractors to be a possibility of a B seat. Does that part make sense? Because right now they don't have opportunity to sit at all, but there's still 2 B seats. So it'll be 100,721 contractors for those 2 B seats. I don't know if is that something that was talked about at all?
I think that's come up. I haven't heard that from the legislature, but I think that's come up. I think that came up in prior discussions, I think, with staff as a possible solution. One thing we could do is reach out to the National Remodeling Association, try to get their input, reach out to our existing B2s and see what they think. Get some research before we make a recommendation.
Yeah, I'm with Alan. I don't think it's really fair to the current B. We'll try again. I don't think it's really fair to the current B licenses, but I do think a possibility for the B2, the 700 classifications to be one of those 2 B seats is a possibility. I think that's the only way that could be fair for everybody.
I have a question and a comment. I do think that because it was brought up through the sunset review, that we should think about being inclusive. But I wanted to know, in certain committees, is there a restriction on a number from the governor to appoint to the board? I know we have 15. Is there a limit? And what is that number?
I want to look at the statute. Dave, do you know offhand?
Well, yeah, right now we're limited to 15 board members. I think what might be a good approach would be to respond to the Senate B&P or the Sunset Committee that, I like what you just said, Mike, that we'll reach out to the remodeling industry and just see if, not that we'd want to propose that they have somebody on our board, but yet they may have members that we could obtain information from. You know, I think that's important because the general building, our B class could do any work the B2 can do. So I think it already covers that. But the goal being that we need to hopefully have more B2 contractors to look at the small remodeling contracts we referred to like handy persons that aren't licensed today. How can we help them to obtain the B2 license, then ultimately the full B license?
All right, anything, other board comment? Seeing none. So that, Chair Love, that concludes the legislative report.
Thank you. That concludes our business for the day. Is there a motion and a second to adjourn? Second. Okay, and any comments from the board for discussion? Any comments from the public?
Actually, I have a comment. I wanted to thank Michael for all the hard work today. I was very grateful for your research and your patience, and of course, Robert's rules, you know. So good job, and thank you very much, Board Member Mark.
Any public comments? We have one person in the public out there.
I just,
Okay.
who motions? Who was
It
the
is
motions?
approximately, you got a second?
Yeah, we did, Jen.
The meeting is adjourned at 4:05. Thank you all.